Good morning. I'll call the meeting to order. We respectfully acknowledge that the Township of Algonquin Highlands is located on Treaty 20 Mississauga territory and in the traditional territory of the Mississauga and Chippewa Nations, collectively known as the Williams Treaties First Nations. We also acknowledge historical shared presence of other Indigenous nations throughout the area, and we recognize these original Indigenous inhabitants as the stewards of its lands and waters since time immemorial. May I have a mover and a seconder to approve today's agenda? Sorry. Oh, that's right. 2 years of online meetings. It's going to take me a long time to get over that. Go ahead, please.
Moved by Councillor Berry, second by Deputy Mayor Jansen. Be it resolved that the April 21st, 2022 council meeting agenda be approved as circulated.
All in favor? That is carried. Are there any disclosures of pecuniary interest today? I have no remarks to make. Adoption of the minutes.
Moved by Councillor Berry, second by Councillor Shortreed. Be it resolved that the April 7th, 2022 regular council meeting minutes be approved as circulated.
All in favor? It's carried. Thank you. And public meeting.
Moved by Deputy Mayor Jansen, second by Councillor Shortreed. Be it resolved that council adjourned its regular meeting at 9:01 a.m. to proceed into a public meeting for the purposes of: 1, review of the Township of Algonquin Highlands comprehensive zoning bylaw pursuant to section 26(9) and 34 of the Planning Act RSO 1990 as amended, and 2, zoning bylaw amendment application laid law AHZBA 222 part of lot 15 concession 12 geographic Township of Sherbrooke.
All in favor? It's carried. Thank you. We'll bring in Mr. O'Callaghan. Good morning.
Good morning.
And he's coming now. Good morning to you both.
Good morning.
All right, you've got your report and then your presentation, so I'll just hand it over to you and take it away.
Sure. I'll just give a brief introduction, sort of how we got to where we are today, and then I'll hand it over to Rick for just a brief presentation. So today's meeting is really, it's the legislative public meeting as part of the zoning bylaw update. This will allow the public to provide any formal comments on the proposed changes that we have made to the bylaw. We did have an open house back in February 24th of this year. No members of the public registered to speak at that meeting, but it is still a requirement that we need to go through. Any written comments we've received have been forwarded to council, and I believe there are 2 members of the public today that will be speaking to the proposed changes as well. But with that, I'll hand it over to Rick, and I'll start the PowerPoint presentation just to sort of go through the details.
Thank you.
Thank you, Sean. Your worship, members of council, it's a pleasure to be here today to review the bylaw changes. I just wanted to mention that the presentation that we will be doing today is quite similar to that was used at the open house in February. By way of background, let's go to the first page of the slide. The official plan itself was updated about 2018, and the current review of the bylaw in part results from that official plan update. It has proposed changes to meet changing provincial requirements, to reflect changes in the official plan or direction from the official plan itself, and generally to update the bylaw itself for any interpretation issues that the municipality has had over since the last review of the zoning bylaw. The approach is to move forward with the new zoning bylaw, which the review started in 2020, and there was detailed council review throughout 2021, resulting in the preparation of the draft bylaw and the presentation at the open house. Next page, please. Yeah. The draft bylaw that is online is a red line strikeout version, so that what you can see when you are looking at the bylaw, anything in red is a change to the current version of the bylaw. Anything that's in the standard black font is being carried forward from the original, from the previous, I guess, which is now the current zoning bylaw. The structure of the bylaw and the mapping is not changing, so pretty much it'll look very much similar to what has been there all the way through. The mapping schedules have also been updated to show proposed changes to the bylaw, and they've also consolidated any amendments that have occurred over the last few years. Similarly, the text of the bylaw has been updated to bring in new provisions and modify some of the existing provisions. Again, as I noted, anything in red will be a proposed change, either a deletion or an addition to the current bylaw. And the bylaw itself has been available for review online since December 2021. But the approach that we take for the balance of the presentation is to focus in on some of the main policy areas that resulted in changes rather than go through the bylaw page by page. We've highlighted some of the particular areas, and the following comments apply to changes that affect the environmental protection zones. The bylaw has introduced an expansion of environmental protection zones based on different natural heritage features that are identified in the official plan and that have policy direction that was set out in the plan itself. So we're going to expand from one environmental protection zone to 4 separate zones. The standard environmental protection zone is found in section 5.1.3 of the bylaw, and it reflects the existing EP zones from the current bylaw and focuses primarily on existing unevaluated wetlands. This is what we've called an overlay zone, where an environmental impact study is required before development can proceed. If the EIS is satisfactory, then the underlying zone, whether it's shoreline residential or other zone provisions, would apply. One of the new zones is an environmental protection 1 zone, which affects existing provincially significant wetlands where development is not permitted. There are not very many of those in the municipality. I can't remember the exact number right now, but I think there are 2 or 3 of them, if I remember correctly. The provincially significant wetlands, I would point out, under the provincial policy statement, development within those wetlands is not permitted, in the zoning bylaw will reflect that. The environmental protection 2 zone in section 5.1.5 reflects areas of natural and scientific interest, and similar to the standard EP zone, it's an overlay zone where the EIS is required before development can proceed. The final zone is the environmental protection 3, which reflects fish spawning areas at or near the shorelines, and it provides for restrictions on docks and boathouses and establishes a 30-meter setback for new structures from the edge of an EP3 zone. The EP3 zone on the mapping, because in some instances it's a very narrow strip, it's more identified conceptually on the maps, although where they connect to the shore is accurate. The bylaw also identifies an environmental protection assessment area, which is an overlay zone where an EIS study is also required before development can proceed on a lot that's within the assessment area itself. It'd be important to check the zoning for shoreline properties that may be affected by the EP zone. This is probably one of the more significant changes to the zoning bylaw itself. The next page is an excerpt from one of the schedules of the map for lands around Clear Lake. And you can see the EP2 zone that's related to an area of natural and scientific interest that's in the green. And the dashed line is the assessment area or the buffer area. So an EIS or an environmental impact study would be required for any most redevelopment that would be occurring within those lands. And you can see in this case on Clear Lake, there are some shoreline residential lots that will be impacted by the change in the zoning. The next set of changes are general, but they primarily affect the rural, the hamlet residential, and the rural residential zones. They will be designed to permit up to 2 apartments in a residential building subject to specific requirements, and those will be found in section 4.1.1 of the bylaw. Bylaw will also be permitting up to 2 accessory dwellings on a residential lot, and that information is found on table 1A and in section 4.1. Again, subject to specific performance requirements. We've been setting up regulations to consider garden suites through temporary uses zoning, and that's in section 4.17 of the bylaw. Garden suites are not allowed as a matter of right in the bylaw. They have to be implemented through a temporary use, and the temporary use sets out the timeline in which those garden suites can occur. The bylaw is also proposing to permit backyard beekeeping on lots over 0.2 hectares or half an acre in size, subject to size and setback requirements. And again, they're in the tables in section 4.5 of the bylaw. Similar to the beekeeping, the bylaw will be permitting backyard hens on lots that are over 0.2 hectares in size, again, subject to size and setback requirements as well. So there are specific regulations that will apply to backyard hens on smaller residential properties. We've also proposed to define and permit hobby farms to recognize farm uses on lots that are over 1 hectare in area, subject to standard provincial separation distances and limiting on the number of livestock. This provides for some limited agricultural activities on lots that are below the size that would be required for a farm operation. The next sections deal with changes to the shoreline residential zones and on lots with shoreline frontage. The first is a provision that septic system leaching beds are to be located minimum 30 meters from the shoreline unless they have an enhanced filter bed system or a tertiary treatment system, where the requirement would remain 15 meters that is otherwise covered in the Ontario Building Code. There are some refinements to the definitions of boathouse and a boat port for consistency. There are also one of the changes, more significant changes in the shoreline area is to recognize the potential to construct seasonal dwellings to the lesser requirements for seasonal recreational building as defined in the Ontario Building Code in the SR2 zone where there is not presently year-round maintained municipal road access. In addition, there'll be a provision to limit the projection of a dock into the water to 20% of the width of the channel or 15 meters, whichever is the lesser. This is in recognition of official plan policies on ensuring that that docks do not potentially interfere with navigation, particularly when you get into narrow channels or narrow bays. We'll be limiting the length of a dryland boathouse to 8 meters, which I think is consistent with other boathouse requirements in the township. There's going to be a special provision set up in section 4.14.9 to regulate the reconstruction of existing dwellings in the SR1 and SR2 zones. It will regulate the permitted increase in the gross floor area width and height based on the distance of the existing dwelling from the high water mark. So there are a number of provisions that will say if your existing dwelling is less than 20 meters from the shoreline, there will be permissions to allow increases in the size, but those will be limited. A few other general applications. We're recognizing that the growth and cultivation of cannabis plants is considered a farm use under the definitions, but that a cannabis production facility that involves the processing or manufacturing of cannabis-related products is considered an industrial use and would only be permitted in the general industrial M1 zone. The section 4.7 of the bylaw provides specific requirements for those facilities, including setbacks and prohibition to outside storage. We've expanded the scope of home occupations to allow home occupations to be conducted in accessory structures in addition to the in the main building. Up until now, a home occupation was limited to occurring strictly in the main house. The next steps from today's meeting, obviously staff and council will review the comments received and There was a report submitted to council on March 17th that summarized the comments received following, up to and following the public open house. Obviously, today's is a formal public council meeting. The notice of the meeting had been posted online, distributed according to all the Planning Act requirements. And the follow-up from today's meeting, the final version will be prepared and submitted to council for adoption, and that's tentatively scheduled for the May 19th council meeting. As we've indicated previously, please continue to be involved. Make sure that you understand the effect of what the changes the bylaw might make on your property, and make sure that you communicate with the with staff to make sure that everything is addressed. Thank you.
Thank you for the presentation and sort of wrapping up the process that's been undertaken to date. I do know that we have two folks who wish to speak to a couple of issues in the zoning bylaw, and they are waiting in the sidebar. I just wanted to ask council if they have any questions so far on what's been presented. We'll go ahead. I'll go to Deputy Mayor Danielson first.
My only question, it would be to Sean and Rick about the process that they go through in responding to the comments that we have received.
Yeah, that's, I have that written down too, that we can, I was asking you folks first, and then I'm going to ask that same question. So we can, is that your question as well? Yeah. So would you gents like to speak to, there were some written comments that were received, and if you've addressed them and feel that there's anything that council needs to consider in relation to those?
So it's the three comments in writing that we received. They have been responded to directly to the people who made those comments. Based on what I've reviewed, I don't see any need to update the bylaw resulting from those comments received so far. The latest comment received is with respect to a specific piece of property within Algonquin Park. So we are reviewing that. I know it is a property that does have some unevaluated wetlands on it. So it will require some further investigation from a staff perspective, but we'll be looking at that and reporting back to council at the May meeting.
Thank you. Any more questions? Councillor Dayu?
Thanks. Yeah, just following up on that, Sean, I wonder, would you just briefly tell us what your impressions were with regards to the first two written comments? There was one about beekeeping on vacant lots, and the second one was about wetland protection and prevention of inappropriate filling of wetlands within site alteration agreements. Could you just fill us in on the context of that?
Certainly. So with respect to the beekeeping, where someone wants to have more than the 5 apiaries, that would still be permitted use on a traditional farm property with the larger acreage. So our intent with the backyard beekeeping was really to limit that number to a lesser number than what would be on a traditional large-scale beekeeping operation. And with respect to the site alteration, this draft bylaw does implement a lot. It expands upon the environmental protection zone. So I think it goes much beyond what our current bylaw does as far as protecting any natural heritage features within Algonquin Highlands. We could of course always go a step further by implementing a site alteration bylaw, but that would be a separate process than what we're dealing with today.
Go ahead.
Thank you. That's great. The other point about beekeeping that was raised was bees on vacant land. Would you kindly speak to that?
Yes. So with most zones, it's not appropriate to have an accessory use without first having a principal use on a property. So for backyard beekeeping, it wouldn't be appropriate to just have a small beekeeping operation on a vacant lot. That would be more appropriate where there's a dwelling already constructed. With a farm operation, our bylaw has always been that a dwelling needs to be present as part of a farm use. And a farm could not just exist on a piece of property by itself as the principal use.
Is that, sorry, my light keeps going off. That answers your question. My question is in relation to the expanded EP zones And having, we have concern for wetlands and other natural features. Or I guess it's an opportunity to inform the public about these changes and the folks who are in the Clear Lake area. Would we undertake any proactive notification so that they know what the changes are? Because in the presentation, we've learned that in spite of this process having been underway for 2 years, nobody attended the public meeting, and we've had only a couple of written comments. So for some strange reason, in spite of zoning bylaw reviews being one of the most important things we ever do, few people pay attention, which means few people will know what the outcomes are. And similarly with the EP zones, if there are requirements, if there's fish spawning areas and we talked about this before, how are folks going to know what the potential limitations are on their properties? And is that something that we undertake through our communications coordinator? Because there are some big changes there. So what are your thoughts on that?
So we did not directly reach out to the people on Clear Lake. I mean, that's showing an example of some of the environmental protection zoning that will impact properties in that area. If it is a developed property, there are some development rights still retained by that virtue. But I guess the simple answer is no, we did just follow the Planning Act requirements as far as public notice. We did not send individual notice to property owners.
But we could ask the communications coordinator to make some of the new changes in the zoning bylaw fodder for his channels to try and spread the word a little bit. I think that's only fair to let folks know what the changes are, and that's why we have a communications coordinator. Okay, so I know we have anything else for council right at the moment, but we're going to bring in our individual persons. Councillor Barry.
Yeah, I'm just as a note, I'm happy to see the expansion with the work that's been done with the environmental protection zones. So just wanted to voice that. Just a clarification. Just for myself, I know we spend a lot of time talking about accessory dwellings and on rural and hamlet, basically anywhere but water. But in the definition, I find I find the definition for accessory building in 3.31 and the definition in 4.1. To me, I don't feel they're congruent. Like in the initial definition, it doesn't say that it can be on an existing on a lot with an existing dwelling, but then in 4.1 it does say that. So I just wanted clarification on that.
Sean or Rick, can you speak to that?
Sorry, could you reference those sections again?
Yeah, so in the definition, it's 3.31.
So 3.31 shows up as cellar, the definition of a cellar.
Sorry.
That would be 3.47 is the definition of accessory dwelling.
Sorry, yeah.
And 3.55 is a slightly different variation of that. It's a dwelling unit accessory that is located within a main building. The dwelling accessory is an accessory dwelling that is in the form of a single detached dwelling. And the section, so those are the basic differentiation of what the structures are. As accessory structures, you have to have the principal structure on the property so that the main dwelling unit would have to be there. Section 4.1 is the one that sets out the requirements. So the section 3 provisions are strictly sort of definitions to identify the terms. And then section 4.1 is where we actually provide for the specific regulations for either a dwelling unit within a building, within an existing house, or a separate single detached dwelling on the property.
Just wondered, am I the only one that felt they weren't defined?
Well, I think the planners are saying that they are.
Okay.
So,
Okay.
Yeah,
There's
because,
a lot of definitions around that, so I just wanted to make sure that it's,
yeah, and it sounds like the difference is an accessory structure versus an accessory use inside an existing dwelling, I think is what you're,
Yeah.
is what you're talking about?
yeah, I just wanted it to be, to make sure I understood it correctly, that in certain areas, you could have a secondary dwelling, not an apartment or.
Mhm.
Okay, fine, thank you.
Okay, so any other questions from council? At this moment, if not, I believe we'll bring in Mr. Gary Trapp first as a member of the public. Good morning, Mr. Trapp.
Oh, good morning. Can you hear me okay?
We can, and we can see you as well.
Oh, thank
You
you.
have some comments to make about the zoning bylaw update?
Yes, I do. Thank you. Thank you, Madam Chair and council members and officials. As mentioned, my name's Gary Trapp. I'm been a permanent resident here for 16 plus years and a cottager for 20 some odd years prior to that. I've gone through the draft legislation, which is great. There's some good enhancements in there. A little bit challenging to follow along, but I first want to thank Sean O'Callahan and Greg Moore for helping me navigate through there and answer some questions. Just an initial comment before I get started. I'm kind of confident that even though you mentioned there's been limited public input, I certainly wouldn't want to equate that to a lack of interest. I was one of the ones guilty as charged not attending the public open house. So anyways, going through the draft, there were 6 items that I wanted to raise for question. If you can bear with me on the first one, it's kind of detailed and certainly the most lengthy. The other ones are very quick and short after that. So the first one is with respect to garages and carports, and it's section 4.2.8 and the encroachments in 4.2.7. So this section, as you know, is specifying the minimum setback for garages and carports to 2 meters from the property line, which is only 6.5 feet. I'd like to suggest that the effectiveness of this protecting the boundary between property owners is impacted by 3 things. And I'd like to speak to each of those 3. One is the point at which you take the measurement. The second one might be the construction design and the materials used. And the last one, which is pretty obvious, is the accuracy of identifying the lot line. With respect to the first one, the point of measurement, my understanding is that it's not, the 2 meter setback is not measured from the closest point of the structure to the lot line, but rather the closest point of the structure that's connected to the ground. And then I think it's addressed through the easement section under 4.2.7C, where it talks about eaves. I wasn't quite clear on the wording about into the required yard, but if I'm understanding correctly, I think that would effectively reduce the setback then from 2 meters and cut that in half to 1 meter if you take a 1 meter easement into account. So in other words, the edge of the building could be only 1 meter away. This becomes a little bit more significant when you consider the second item impacting the construction design and materials. It's pretty easy these days to design a large building. It could have a cantilevered roof that could hang over 4, 5, 6 feet, whatever. I think if I understand correctly, the encroachment section would cover that as it would consider it to be an eave, but that's just something I'd like to get clarification on. Probably more importantly though, with respect to the materials, if you put a steel roof on a garage and say it's a fairly large garage and it's got a 612 pitch on it, the snow shedding off of that in the wintertime, and as you know, slides off quite easily off a steel roof, that could easily shed 10 feet away from the outmost portion of the structure. So in other words, 3 meters or more. And that can land on a neighbor's property and damage the neighbor's existing building or trees or whatever they may have in their property. So I think that the resulting damage, it could be pretty obvious depending on the structure and with the eave encroachment for the building. So a couple of suggestions there respectfully that might be considered is a modification to just go from the closest point of the structure to the property line. That would alleviate any need for determining eaves and measures and so on. And it would clearly try and protect that 2-meter boundary. And with larger structures that we're seeing these days, you know, a large structure with a steep roof and a steel roof could be pretty common. Regardless of what might be suggested for a modification, I was wondering if there might be an opportunity for something very simple to add in that whatever, regardless of what structure or measurements are used, that the person doing the building, the onus is on them not to go beyond the property line in terms of encroachment, in terms of snow shed and drainage and so on. And I think I appreciate that there might be other vehicles or avenues for a neighbor to take civil action or whatever, but I think it's pretty easy these days to put some retaining mechanisms in place on things like steel roofs and put the onus back on the person doing the building rather than the person neighboring having to try and remedy something or prove some damage or claim after the fact. I think it would just be helpful, it'll go a long ways in being clear and maybe not aggravating neighbor relations and that sort of thing. The third item is the accuracy of the lot line. And again, fairly obvious, but the first thing I'd like to say there with respect to setbacks, it's only as good as the accuracy. So I'm thinking that, I just sort of lost my train of thought here, sorry. Yeah, right now, my understanding is with a building permit for construction of these accessory buildings, or maybe in fact any building, it's acceptable to submit a sketch, which is, you know, not a problem. There may or may not be a survey on file, but it could be, we know the challenges of trying to identify lot lines that can be very challenging with trees and such. So I'd like to say what I'm not suggesting here is I would not suggest that we would want to see an OLS survey in all cases for building applications, because I think it may not be necessary. It might be extra cost that's not necessary. And with the time constraints of OLS surveyors these days, it could add a lot of time to the construction process. So that's not what I'm suggesting. What I am suggesting is I'm wondering if there's an opportunity for some wording that would balance, you know, on the one extreme, taking a sketch and the applicant's interpretation of property lines to the other end of the scale where the township just says an OLS is required in all cases. And the balance might be, you know, if there's an existing survey, even an old one on file, and the applicant can demonstrate to the building official where the line is, then maybe there's an opportunity to give the building official the authority to determine whether an OLS, a new OLS survey is required or not. It's going to require some judgment and a little bit of balance, but I just like that idea that regardless, you know, the onus should not be again on the neighboring property owner to who's doing the construction to prove that the line, the property line has been violated or encroached for setbacks. Excuse me just for one sec. So that was just my thoughts there. When I read through this again, I did share a concern that was just raised earlier this morning around accessory buildings. I too was having to take a second or third read through with respect to accessory structures. It refers to sleeping cabins, and in the definitions in I think 3.1 and 3.158, it defines accessory buildings except for sleeping cabins, it says, and then sleeping cabins are defined, but I didn't see any specific section on sleeping cabins themselves. And I may have missed that. I apologize if I have. So two specific questions I'd like to leave relating to that is, can sleeping cabins, can they or can they not be, are they included within this 2-meter setback for accessory buildings? And then what about a garage with a sleeping cabin and the 2-meter setback? Is that any different? So again, my apologies if I'm confused on it, but just some clarity around that with respect to sleeping cabins, accessory buildings, and setbacks would be much appreciated. And that was the first item, as I promised, the longest of them all. The second item is coverage, lot coverage in section 4.2.6. Again, this is referring to accessory structures being 5% of the total lot area. Table 2 talks about lot coverage maximums ranging from 10% to 40%, depending on the various property types. I've just got one observation here and one concern. The observation is that, at least to my reading, table 2 is unclear if the accessory structure maximum of 5% is included with the table 2 totals or in addition to the table 2 totals. And my concern there is, if you take an example of an SR1 property type, the maximum coverage is 15%. I've done some calculations on different lot sizes, say as an example, using SR1 properties. And if you use those percent coverages, I would respectfully suggest that on smaller lots, those percentages at 15%, even if it does include the 5% accessory building, they are very generous. And when you get into larger lots, larger acreage, those percentages, the calculation of coverage becomes really excessively generous. And I would suggest in some cases, pretty wildly generous. So again, here's what perhaps consideration could be given to clarifying that the 5% is included in the table 2 maximums, regardless of how it might have been interpreted or applied before. Obviously, these percentages have a big impact on the aesthetics of our neighborhoods when you start talking about larger buildings and percentage coverage. Perhaps another suggestion to consider might be a sliding scale of the percentage based on the acreage. And it sounds complicated, but I'm not sure that it would necessarily have to be that complicated. It could be just certain property types where there might be a sliding scale for acreage to apply the percentage. Another option might be just to reduce the percentages, but that may not solve the concern that I have anyways. Or it might just limit the number of accessory buildings, might be a consideration. Again, these might all be things that council has already considered, but that's just my observation as a member of the public reading through it. The next item is trailers or mobile homes. That's section 4.41. Talks about prohibiting trailers. I think I've seen Township addressing some issues with year-round trailers that are being occupied. My comments are more maybe around seasonal use of trailers and mobile homes. Our neighborhoods are getting pretty busy as more and more people decide to reside year-round, and more vacationers and visitors. And we're all competing, or not competing, but we're all limited to the same short, nice weather periods. So I would suggest these seasonal use of trailers are maybe becoming a bit of a problem. And with respect to the enforcement, I just, again, a couple of questions I'd like to leave for clarification. What's the mechanism for reporting on trailers that are being misused, especially after hours, when building officials, rightly so, are not available? And what are the consequences or penalties of misuse of violation of this prohibition of trailers? penalties need to be, if there are any, and again, I apologize if I missed those in one of the tables, but penalties, in my opinion, need to be significant so they don't just become equated with the cost of a camping permit and not very effective. With respect to the exceptions of trailers in section 4.8, which allows temporary trailers during construction, just wondering if there's an opportunity for some clarity around, my understanding is that it's linked with the building permit. Is there any limit to the number of trailers or the time limit of temporary trailers? And again, just a comment for my 2 cents worth, I'm not in favor of a permitting approach for the use of trailers. I think that would just create maybe an open season and inviting abuse of misuse of trailers. The next item is building permits. Concern here is just over the timelines on a few of the components for building permits, specifically sites that tend to become perpetual construction sites. There's no limit, as I understand it, on a construction permit. We all want to accommodate reasonable construction and over a reasonable time frame in our neighborhoods. Again, I'm just wondering if there's an opportunity for a balance with the reasonable expectation of those who are not doing the construction for peaceful enjoyment of their properties during, a limited summer season, for example. Again, some suggestions here for consideration. Maybe put a time frame on construction permits of, as an example, 3 years would line up with the variance application timelines. Might provide an incentive to expedite the construction. And again, there's a link here to temporary trailers. With respect to specific timelines, just a couple of questions on occupancy permits. Is there any time frame linked with a person getting an occupancy permit after the actual occupancy of the property? And I appreciate that that's probably a resource issue trying to follow up on occupancy permits. But I just wondered if there might be some link there, an opportunity to put some timeframes in. The next item is docks. That's, as you know, a new section 4.2.9.EII. This is an example, I think, of an area where, even though there maybe has not been much public interest expressed in the zoning bylaw changes, this one, I'm sure, as we all appreciate, would be of great interest to a lot of people. I'm unclear whether this relates to permanent or seasonal docks. We've got so many lakes up in this area where the 15-meter length restriction of a dock just doesn't satisfy the need to get into sufficient water depth to accommodate boat motors and such. And I think there's a lot of places where the docks would be longer than this length and would not be interfering with any waterway navigation. So a couple of questions: are seasonal docks excluded from this? Is there any depth considerations as long as it's not interfering with navigation? And if it does pertain to all docks, I could foresee a lot of issues here with property owners and the township in terms of practical terms trying to administer this, whether you include grandfathering or variances or sales of transfers, and what happens if the property owner doesn't own the property adjacent to where they're putting the dock out. So I think there's lots of potential issues and concerns on that one. The last one is trucks and buses and coaches and trains and whatever else is in there, derelict vehicles. That's section 4.42. Lots of things covered. Just an observation there and a question. With derelict vehicles, now that the provincial government has taken off the need for stickers, I'm sure they probably haven't done any favors to our OPP officers trying to identify vehicles that are not current. I'm not sure what the township opportunity is to access plate information now that there's no visible indicator on a derelict vehicle, whether it's current or not. But with respect to enforcement, I'd like to further follow up, I'd say this meeting, how is that enforced in the bylaw? And what are the consequences of violation of that? So that very quickly, sorry if I've been speeding through it too quickly, but I really do think there's some opportunities here. I appreciate the effort that's been put in so far to date. And I just think there is a few opportunities to tighten up in a few areas. I hope these comments have been clear enough and constructive. I think it's worth the time for further investment of time on some of these things. And if there's anything I can do, I did not submit written suggestions here. As you can imagine, it's fairly detailed and complex. I thought the easiest route or quickest way might be just to do it orally. So I'd be curious to know maybe what the next steps are. And just again, thank you everyone for your attention and for the time you put into it and for your consideration.
Thank you. And I would say thanks back to you for the amount of detail that you've undertaken in some of these areas, some of which, you've had some personal experience with. So it's understandable that detail has been undertaken. I think you've raised some really interesting points, and I hope you appreciate that Sean and Rick can't scribble down your questions and then answer them today. So what they'll do is, there's about 4 people who have taken extensive notes, and you might provide some of yours if necessary to Sean, and then they could bring those back for council's consideration at the next meeting. It is the intent to pass the bylaw at the next meeting, but certainly if anything you've raised, I guess, raises an eyebrow with the planning folks, then that, a little bit longer time would be necessary. So I don't know if Sean, if there's anything that you or Rick can answer immediately in a couple of those quick things. I mean, the permit part is a different department, but is there anything that you can answer quickly today that Mr. Trapp has asked, or would you prefer just to take it all away and bring it all back to us next time?
I guess with respect to the sleeping cabins, there is a section in the bylaw that does speak specifically to sleeping cabins, and there is a setback requirement greater than a normal accessory building for that. So that one, and building permits and occupancy permits, those are not dealt with through the zoning bylaws. So that would be a separate process. We'd have to look at for that. But other than that, we'll go through the comments and report back to council with any suggestions.
Okay, and if you need any further clarification on Mr. Trapp's concerns, you'll reach out to him for that clarity?
Yes, absolutely.
Okay, terrific. Again, Mr. Trapp, thank you for your comments, and again, thank you for the extensive amount of work that you've done in asking some good questions.
Thank you, Madam Chair.
We'll thank you for your time and carry on from here.
Thank you.
Thank you. The second member of the public who wishes to address council on this matter today is Mr. Wayne Simpson, and so I think we'll bring him in. And council did receive a letter from via Mr. O'Callaghan, a letter from Mr. Simpson regarding his client's property. Good morning, Mr. Simpson.
Good morning, Madam Chair.
Thank you for joining us. You've got some comments on a particular section of the zoning bylaw you'd like to provide comment on.
Appreciate that very much. Good morning, council members and the public. And I do appreciate the summary that was presented by Rick Hunter, and he did broach on this particular section that I want to refer to. My clients are Stephen Douglas and Patricia Fitzgerald, and they recently acquired a property on Whitefish Lake. And it's down towards the the Rock Lake Campground, I believe. So it's accessed through Algonquin Park. And the property does have an old cottage on it, maybe more akin to a cabin or so. It's got a sort of a covered porch around part of it, and it's somewhere between 800 and 900 square feet. And it's in dire need of reconstruction. And so my clients are looking at how they could redevelop the property to suit their purposes. And And what they've decided is under the current section, actually, I may have misquoted the section in my letter to Sean, but I believe it might be 4.10.5 as opposed to 4.14.5. But in any event, the current cottage is legal non-complying, and the setback is 7.5 meters to the corner of the building, closest corner of the building to the lake. So, it's unusually close, but not historically unusual. And they have the ability to enlarge the cottage, provided an addition is made. Any addition made is 15 meters from the high water mark. And that's some options that they have, but they would rather look at maybe foregoing the existing 7.5 meter setback and then building a new cottage back at 15 meter setback. So I think that would be an overall improvement in terms of the intent of the official plan and the zoning bylaw. Mr. Trapp mentioned through his discussion on lot coverage how there's a bit of an inequity or sometimes a distortion in what would be reasonable or appropriate when it comes to lot coverage based on the size of the lot. 10% of a small lot is a number, but 10% of a large lot is a much greater number. So in this case, the municipality is proposing changes to the bylaw. I believe the section is 4.14.9, but again, I might have that wrong. But Sean knows the section I'm referring to. And this is the one that Rick Hunter mentioned in his presentation about the changes to the bylaw would allow the percentage increase in the gross floor area of a cottage to increase a non-complying building to increase the further by incremental amounts the further you go away from the shoreline. And that, that sounds very fair, and I think it's a reasonable approach, and it's something that I see in other municipalities. And it's one thing you're trying to write a zoning provision that sort of is fair in every instance. But in this particular instance, we're not quite sure that it is fair because we're starting off with a cottage that is, somewhere between 800 and 900 square feet. So again, a 30 or 40% increase in the size of, in the gross floor area of a cottage of that size, is a certain number. But if the cottage is larger to start with, then the percentage increase could be, the effect of the percentage increase could be much greater, of course. And so, so we're just not quite certain that that there's equity in that provision, and we would like to ask council to consider an exception or an exemption or something in the bylaw that would apply to this one particular property owned by my clients. And so what we'd like, excuse me, what we'd like to do is, have a discussion with Rick, certainly Sean, and possibly Rick, to discuss how the concerns of my client might be better reflected in the bylaw that's ultimately approved by council, maybe on May the 19th. So we would like to have further discussions to see how an exception could be crafted and incorporated into the bylaw, because we believe that the section that 4.14.9 is unfair in the circumstance where the existing cottage is very small. And so we really look forward to having an opportunity to work with staff and Rick to discuss that, and hopefully that staff will be able to bring back to council on May the 19th a new provision in the bylaw that we would all view favorably. And I thank you very much for your attention and consideration this morning. And I'm available should there be any questions. Thank you.
Thank you very much for your comments. I didn't know, Sean or Rick, did you have any comment you wanted to make at the moment?
Not much, but I'm certainly available to speak with Mr. Simpson and Rick, and we'll review this along with the other comments and bring something back to council for sure. Okay, that's what we'll do then. Mr. Simpson, thank you for your time.
Thank you very much. Have a good day.
Thank you. So we just had just those two folks who wanted to make some comment on the zoning bylaw. So Based on certainly Mr. Trapp's extensive list with some interesting questions and the specific request for Mr. Simpson on behalf of his clients, which is a bit unusual because I think they could go to the Committee of Adjustment if they wanted to. So, so we'll go to Councillor Dayu, who has her hand in the air.
Thanks very much. Just on the presentation by Mr. Simpson, I appreciate that he's requesting consideration for that particular property, but the equity question is a good question. And I wonder if perhaps Sean, when he comes back regarding that request, could speak to the issue more broadly.
Yeah, and I believe he will. And I think council will recall that we had quite a conversation about how to encourage the building of new construction farther back. And so we did put a lot of work into that, and the sliding scale was what we came up with. Yes, an interesting point has been raised. However, I think it falls into the, if you happen to own a small property, if your property has a small building on it, it has a small building on it. Like we can't, I don't know how you'd start making special arrangements for everybody based on, everybody doesn't get a 4,000 square foot property or a house. So we'll leave that with planning staff to come back with after some thought. Sean, did you want to say something there?
Yes, just on that point. I mean, with the zoning bylaw, it's hard to anticipate every specific situation. We have to look at it through a general perspective. There's always the opportunity for someone to apply for a minor variance if, in their particular case, the rules don't quite work in their favor, and those are things we look at when we review those applications. But it's hard to capture all of that in this document. So there will always be that I guess perception of inequity, but there are ways to address that later on.
Mm-hmm. Yeah, excuse me. So that will come forward with in final reports. Any other questions from council on the matter before us at the moment? So we know that we've got some things coming back at the next meeting in May, and the questions that have been raised by the public today will be addressed therein. Everybody okay with that? You have a resolution? Right. Okay, then we'll just move on to the next one, which is the second public meeting. Sorry, Sean, go ahead.
Sorry, just a point of clarification with respect to additional public notification. Council was discussing reaching out to specific properties. So is that something that the council would like us to do, specifically with the properties around Clear Lake? Or
no, I was speaking more of is finding a way to provide the courtesy of informing folks of specific changes. It could, back to the equity question, it could easily be argued that this process has been in place or underway for 2.5 years, and this document has been available for public comment since December. My concern is around, lake health. We're putting a lot of work into lake health and shorelines and naturalization and preservation of wetlands. And so if you're a property owner who is going to be subject to some specific changes, such as the Clear Lake area. I mean, we can talk about it. Council can weigh in on this, obviously, but it just crosses my mind that it might be prudent to let folks know ahead of time of things in specific areas like Clear Lake. I'm sure there's not 5,000 cottages. There's probably a handful of properties. Is there a way to let them know that there are going to be changes that may affect work they want to do in that specific ANSI area? And I'm not talking about emailing every lake association and telling them the changes that are happening on their lake. This is the Clear Lake area is specific and of particular interest. So I think it might warrant a little bit more effort. However, that informational effort can be made through our communications coordinator. So it's not a question of you guys as planners doing anything at the front end of this, but the township finding a way to communicate some of the changes at the other end. So any thoughts from council on that? Just trying to be a little proactive in, zoning bylaw is, when it's finalized, has been changed, and here are the changes. That's what our communications person is for. So I see nodding heads. So if that's okay, then we'll move on to Deputy Mayor Danielson, who has her hand in the air.
Just a couple of items not related to that, but during the course of our discussions, we did come up with several things that we'd like to see worked on, and I just want to make a note of that. And one was property standards, which might deal with some of the issues that have been raised by members of the public. And the other is a night skies policy that was something that came up during the course of our discussions. And I just wanted to put it on staff's radar, that those, and council's radar, that those are, two subjects that we'd like to see followed up on.
Mhm. Yeah, and I did speak to Sean yesterday about dark skies in relation to the next public meeting because of the letters that have been sent. So, and Councillor Barry has raised it a number of times, and I think there is broad council concurrence for that moving ahead. So I did say to Sean that needs to come forward sooner than later, and Madam CAO.
And with regard to property standards, that has been one of the first things that our new bylaw officer has been given to work on. So underway.
Yeah, that's good. That's good news. All right, so Sean, if you could take us through, Rick, are you leaving us now? Well, I don't know what you said because you're on mute.
Gone up. So yes, I think I would be finished at this point if the public meeting is over, and guess we'll see you at the council meeting.
Yes, thank you for your time today.
Thank you so much. Okay, bye now.
Bye now. Okay, Sean, if you would take us through the application for the amendment.
Yes, this property is located on Russell Landing Road. It's currently zoned recreational commercial exception 13 and designated rural and waterfront commercial in the official plan. The property is approximately 18 acres in area with 168 meters of frontage on Russell Landing Road. Surrounding uses are generally recreational, commercial, rural, and shoreline residential. And the lands are currently developed as a marina storage facility. The owner is proposing to allow a private sports court facility as an additional permitted use on the property. The proposed private sports court facility would be located entirely within an existing storage structure on the property and would comply with the township official plan. Within the current zone, being recreational exception 13, the uses are currently restricted to a boat storage, conservation, a single detached dwelling, and a public use. The proposed amendment will rezone the lands from recreational commercial exception 13 to recreational commercial exception 15, which would allow a private sports court facility as an additional permitted use on the property. Notice of the rezoning was posted on the property, circulated to all property owners within 120 meters of the subject land, posted on the township website, and circulated to all prescribed agencies. One letter of support has been received and 3 letters of objection have been received, and those have been circulated to council. The objections are related to concerns of light pollution, increased traffic, and noise. With respect to light pollution, the property is currently under site plan control, and the site plan agreement does say that all external lighting facilities on the subject lands must be motion sensitive lighting and prevent light trespass and glare onto neighboring properties. That section will continue to apply to the property should the zoning amendment be passed. Staff do continue to recommend approval of the bylaw as presented today, and happy to answer any questions should council have any.
Thank you for that. We have 3 members of the public who would like to speak to this. But before I do that, does council have any questions of Sean for what he's told us so far? The only addition, and I did speak with Sean briefly yesterday, that yes, the site control is there in regards to the lighting. I think the folks who are concerned about the lighting raise a very good point. And it aligns with what we've been talking about. Is it necessary, I'd like to ask council, is it necessary to add an extra part of lighting to ensure that it's down lighting as opposed to, because you can have, it's motion sensitive lights can be, they're not supposed to have, trespass or glare onto other properties. And Sean can probably answer this, but is it necessary to specify that any outdoor lighting be down lighting as opposed to just lights that go off after 5 minutes, because that itself can be really annoying. So I'll just leave that with council at the moment, and maybe Sean can speak to that.
I'm confident that that would be addressed in the current wording, where it does note that light cannot trespass from this property onto neighboring properties, as well as it can't glare onto neighboring properties. So my interpretation of it would be that it really the light has to be contained on this property and cannot go beyond the property lines, but we can certainly amend the wording if council wishes.
Yeah, and I believe the agent for the application is one of the three people who'd like to speak to it. So we can perhaps ask her if she can, agree to that kind of thing. Councillor Dayu.
Thank you. Question for clarification for Sean. The point of light not being able to trespass onto other properties, is that direct light or direct and indirect? Because there's one thing where you see a patch of ground where there is light from a neighboring property. It's another thing to look towards another property, maybe several meters away, and there's a big bright ball in the sky that is stopping you from seeing the stars. I'm wondering, does the wording cover both?
My interpretation of it would be that it's really just while you may be able to see the light on the property, it can't shine onto the property. So I think it's dealing specifically with direct. Also by restricting any lighting to motion sensitive lighting, it's not a light that's going to be on throughout the night. It's only going to come on when it's activated and then shut off shortly thereafter.
It does, and I suppose I'll have a follow-on question for the property owner, should they choose to speak to that.
Good morning, Mr. Weber.
Good morning. Good morning.
You look like you're in a hockey change room.
I had to cover up my basement. Yes,
Oh, well, there you go. Were you able to hear our conversation prior to you coming on the screen?
I was. Yes.
I
Yes.
believe your concerns are around lighting, so if you'd like to let us know what you think, you can make
Yes.
your comments now.
So thank you. Good morning, Your Worship, members of council and the public. This is a first for me, so bear with me, but appreciate the opportunity. Hello, Sean. So it appears my letter has been sent to council, so everyone has read it. So if not, I'm able to read it if you'd like, but I'll assume everybody has read through it.
Yeah, your letter has been circulated, and that was that, along with a couple of others of a similar nature, were the basis of the discussion that we just had about the lighting and the existing site plan control around lighting.
Okay, thank you, thank you. So I guess I'll start based on the follow-up conversation around the lighting. I guess my concern is, and let me point out where I'm located. So I'm located due east of the property in question. So I'm the small half-acre lot immediately east of the boat storage lot. Recent cottagers we've just recently built, and it was obviously well known that it was a boat storage, and the seasonal traffic that is going back and forth there. There is lighting there already that is not motion sensitive, but it's low enough. We've adapted. That's fine. But I am concerned about the hours of operation. So that's an unknown to me right now, because if there's traffic going in and out, then it doesn't matter about the motion light. That will be on most of the time. So very concerned about the light. Again, there are ways to mitigate it, but I think that needs to be dealt with if this proceeds on. So it's around the hours, around the light, and I do have a question around the upkeep of the grounds itself. Obviously a new resident there, but it was my understanding in 2012 when the storage buildings were built that there was promises of cleanup. There are still old boats that still reside there. There's racking systems for outdoor storage that is not being used. So I think we need to be considerate of previous history, although previous owners, right? The new owner has only been there for a year or two, but I think we need to be conscious of, will there be cleanup and consideration of that when I would imagine a parking lot gets put in and parking lights, et cetera. So I guess it's around hours of operation, in addition to what I've, suggested in my letter as, and the hours of operation and cleanup of the lot itself. But again, I still think the lighting, the area, as well as the traffic. If you have driven Russell Landing, you'll understand that there's a very sharp S-bend between the two marinas going up to the property in question and my lot on towards Old Mill Marina. And I would imagine increase in traffic coming and going of the to the sports facility. So again, as it related to my letter, I'm not opposed to a indoor facility somewhere, but I am opposed, and I look for council support to decline the application for where they want to put it, and next to the lot on Russell Landing.
Okay, thank you. Thank you for your comments, and certainly appreciate your concerns. These, it's a difficult balance to try and grow a community and have progress, and also meet the needs and requests of everybody involved. So, but that's why we hear from everybody and have conversation to come to the best outcome. So I thank you for your thoughts, and they have definitely been noted and recorded.
I'll
So I
stay
think-
on if there's any questions for me. Thank you.
Thanks. Yeah, I think you'll go back into the other section, and I'm just speaking to this. I have Yelsky and then Alicia from, that's who I have. Okay. So I guess then is Robin and Rosemaria Zielski. I apologize if I have not pronounced that correctly.
There we go.
Good morning. How are you?
Good morning. How are you? This is
Very well. Have I pronounced your name correctly, Zielski?
Zhukovsky.
Oh, I really didn't get that anywhere near that.
That's okay. Everybody has trouble with our last name.
You have some comments to make around the application that's before council, so please go ahead.
Yeah, thank you very much, Madam Chair and Council. Yeah, our concern, and we have a couple of questions, and basically we're echoing what Kyle had said earlier. But our concern too is the as well the lighting issue. As Kyle pointed out, that the property does not currently have motion sensitive lighting, so that would be is not in compliance with the requirements. Also, if the township had a dark sky policy, the light that glares onto your eyes would not comply with a dark sky standard. Also, our concern too is when it comes to what model is going to be used for accessing the facility, because if it's going to be, is it going to be a subscription service or a club service, then it's only 2 courts that they're proposing. That would mean that what's the hour of operation going to be? Because if you're a club and you're going to offer a subscription that says you can join, you can do tennis at any time, you just have to book a time. They could be there at any time. People could be coming and going at any time. And to Kyle's point, that means traffic in and out will always have the lights turned on. So also, there's going to be a lot more traffic up and down the road. That's going to put a lot of stress on the road. As Kyle pointed out, there's a sharp S-bend, which means it's very hard to see people when you come up that road because people are going to be gunning up that hill. And if you're walking on the road, It's very easy for something to happen there if there's because it's not an easy place to navigate. So that's our main concern and our objection to this. I don't think it's appropriate. This is an appropriate location for a facility like this. This is more appropriate for an urban location. This is a zoned as rural area around our where we are. And by the way, our property is the one that butts to the old mill. We're right next door to Mr. Kyle, and we're the acreage that is goes right against the old mill location.
Okay, well, thank you for those thoughts. I am looking on the GIS at the property layout, so I see exactly where you are. And so we have one more person to hear from, which is the agent for the application. So I think I'm certainly interested in hearing from her about the questions that the neighbors have raised and see what the plans are there. So thank you for your comments, and they have been recorded, and we'll carry on with our next person.
Okay, thank you very much for hearing us out.
Thank you.
You're very welcome. Thank you. And so I believe Alicia Dudesky is next, and she is the agent for the applicant.
Hello.
Good morning. How are you?
Wonderful. Thank you. Yourself?
Great, thanks. So you've been listening, I think, to the folks that have spoken, and we do have a number of letters of objection, and they all seem to be along the same lines.
Yep.
Are you aware of the current controls for lighting on the property?
Yep. And we do have motion sensor lights in. There are 2 buildings, and they both have basically just bulbs for safety reasons when we do end up getting up there at night, just so we can see. They do both face down, and they're above the main entrance doors, not the garage doors, just the main entrance doors. And they are by auto, like it's censored. So I'm not sure. Maybe there's something I'm missing, but that's all that I'm aware of because I recently replaced one. So I know they are there. In regards to additional lighting concerns, as Sean mentioned, it is a proposal for an indoor court. And yes, it is going to be open during our open operational hours, and which our latest hours go from 9 a.m. to 7 p.m. from Friday, Saturday, Sunday during our heavy season of July and August. As I'm sure you know, it is a storage facility, and that is our primary use for it. So it's mostly just boats and a couple of tractors and a couple of diesel forklifts. So that is the current commotion going on site. So by saying it's a residential rural area since many years now, it's not. It's been a commercial facility, and I think the residents have gotten used to our tractors and appreciate us being able to launch their boats and get them over to their water access cottages in a timely manner. So we have been running a business up there. But with saying that, it is a, boat storage facility. So in order to open the courts, we need to empty the boats. So the opening months of this facility for the sport courts would only be during July and August, because prior to that, it's filled with boats and not safe for people to go into. And after that, it's filled with boats. It's not safe for people to go into. So it will definitely be a seasonally run facility. And it's basically just an opportunity that we wanted to provide customers and locals to have a method of playing sports, and pickleball specifically, rain or shine. That was the idea behind making it indoors instead of outdoors. In regards to the traffic to and from, I would just, highly recommend that people be careful when taking that S turn. It is quite hairy. I've been here over a year now, and I still have a little moment and to look both ways before doing that little turn, and especially when we've got boats under tow, because we do deliver boats and we offer a variety of services to our customers. So It does get hairy, and especially again with the cottagers who come up and park at our facility. Sometimes it does get more than one car, knock on wood. I've never experienced it myself where I'm passing two ways traffic. But I'm sure during the summertime when I'm stuck on site running the facility, there are more traffic. And I guess that's all the concerns. I mean, for noise, it's indoor, so it's not. I mean, how much noise can 2 versus 2 pickleball players make? I'm not sure. I've actually never played pickleball, so okay, so that's the thing, right? I've never done it. I've actually never even heard of pickleball until the owners proposed it, and I was like, "What is this?" Google. So it is a 2 court proposition. But I guess that's about it. I mean, it's not a drastic change to our operational side of things because, again, it is kind of just using the facility in a different way when it's on its low time of July and August, because that's when it's typically empty and the boats are in the water. We don't have any intention of creating anything more of a parking lot that's already there. It's just a big open grounded area. We usually have trailers and our own trucks parked in that area. Again, there's 2 courts there, so we don't foresee very many vehicles more than the typical are going to be up there. But that's all I really have to say. We're just hoping to bring a little bit more entertainment and things to do with people and family and friends on rain or shine days.
Thank you for that, Deputy Mayor Danielson.
My only question for you would be, do you plan on maintaining the same hours for people to be able to use the courts?
Yep, as mentioned, our earliest or our latest, our longest days are 9 a.m. to 7 p.m. It is going to be a locked facility. There's not going to be any fob entrance. So when people book out the courts for their usage, we will go up there and open it for them. And once they're done, we close it down. We don't want anyone, just anyone going in there for just obvious safety reasons. So we will be monitoring it quite closely, and we'll only open it up to the people who book.
And pickleball is really popular, and so
apparently,
yeah, it is. And so I guess there was a comment made about, do you have to subscribe or be a member of something? So can anybody use it if they call ahead and just book a court? Anybody can use it.
Yeah, I think we want to open it up to everyone. I know the Dorset Recreational Center is at a closed status right now, just to some mold issues that they've been dealing with, and they don't have a proposed opening date, just because I believe from the document that I read, it seems like it's going to be quite a substantially financial exploration to solve the problem. So, I mean, if we're able to open it up to those people who are missing out in that opportunity, then yeah, of course, again, it just has to be booked online through us. We'll go up there, open it. But once my doors close at the marina, the storage facilities close as well. And again, I mean, latest 7, maybe 8 p.m., but then it's just shut down facility.
And so if it becomes really popular and people want to play at 7 or 8 at night, what is the possibility of, in planning, we call it debt creep. What's the possibility of it being so popular that you just stay open till 9 and then till 10? Because I think that's what people are concerned about is.
Yeah, sure. I understand that as well. Again, it is a security concern for us, like a huge security concern, because if you've ever been in that building, A, it's massive. And B, there's actually racks on either side where the boats go. It's 4 stories high. We do intend on putting mesh nets there. So A, the ball can't roll under, so people can't climb, etc. But again, people will be people and they might get a little nosy and lift it up. So the answer is no. When my hours close and when my staff goes home, when the marina is closed, that is closed. So I have no intention of paying staff extra hours to babysit people up in that facility. It just wouldn't be financially feasible at that point. We do want to offer this as a very fun adventure and something to do, but I mean, I'm not going to take a financial burden to it. Sorry, if you want to play pickleball at 10 p.m., go elsewhere.
Yeah, fair enough. Well, thank you for answering those questions, Councillor Dayu.
Thanks. Quick question for me regarding traffic along the S curve. Do you have any sense of how many people might wish to boat to pickleball?
Easy answer is no. Honestly, again, I had no idea that pickleball was even a popular thing. So I was like, I'd be lucky if 1 or 2 people play. But apparently it is quite like an evolving sport. So, I mean, if they do boat in, awesome. Like they can come more up. I've got a couple of transient docks that they can come boat. It is quite a walk up the hill to get to the facility, like quite a walk. So, I mean, they might get exhausted before even exerting themselves during the game, but it is a possibility that people may boat in. But I mean, the property is not water access itself, right? Like you have to like park your boat and walk I don't know, have like a 15-minute walk up there. So I don't know. Maybe if it is awesome, great. But if not, c'est la vie.
Yeah, because logistically, I think it's not, I don't think it's related to, support or opposition to the application. It's more of a curiosity, is if somebody boats in, yeah, it is, I mean, it's quite a walk. So
It is.
I envision a golf cart somewhere. Okay, does anybody else have, so you have nothing more to add to the conversation then, Alicia?
No, I don't think so. I mean, it's pretty self-explanatory in the sense where it's going to be open July and August when the boats are out there. So it's a safe facility. The opening hours would be the marina operational hours, just for staffing purposes. And the outside of the site have no changes planned whatsoever, and don't foresee any required changes in regards to lighting, parking barricades, or anything like that.
Okay, thank you. Councillor Barry, you have a question?
Yeah, just I think in a couple of the emails, there was concern about possible expansion. Is that something that you see happening as far as, if pickleball takes off or the marina expands, like is expansion in your near future plans?
Do you mean more pickleball courts?
Well, either developing the infrastructure at the facility or more pickleball courts.
Well, I think the matter before us today is pickleball courts. So
I'm not sure what the future of Old Mill Marina holds. Like it's been a very exciting first year under the new owners. And there's, I'm sure, lots of opportunities for cool things to happen on site. But again, this is just for pickleball courts inside the building, and we have zero intention of changing that building. It's immaculate as it is. Wouldn't really want to change the structure, like the size of it or the compounds. It's pretty great. So, I mean, the main purpose is storage, right? So.
yeah, and somebody else, which is, I thought this is what Councillor Barry was going to ask, is one of the letters of concern was around it potentially becoming an event space, which would be a nighttime thing. But the application is specifically for courts, sport courts. So could you speak to that? Is the intention to make the space available for in July and August for anything other than pickleball that would generate the public concern about event space?
No. It's just for the sport courts, as mentioned. I mean, I don't know how we could use it as an event space. And I mean, obviously, again, operational hours are operational hours. So, I mean, if you're thinking like a wedding venue or something, I'm not sure what's being proposed or being suggested, but the answer is no. We're looking forward to sport courts only at this time.
Okay. Does anybody else have any questions for Alicia? No? Okay. Well, we'll thank you for being on the screen today and answering some of these questions.
Of course. Thank you.
We will carry on with our conversation. Thanks. Sean, do you have any comments based on what you've heard so far from the public and from the applicant?
No, I continue to support the application. I think the concerns are addressed, specifically with the hours of operation and the months that they'll be operating. I can't see there being a significant impact beyond what's already occurring at the property. So yeah, my recommendation stands to support.
Okay, questions, comments, thoughts from council on what you'd like to do around this application and some of the questions and concerns that have been raised. Councillor Dayoud.
Question for Sean. Sean, that S curve, it is a point, it's probably my only remaining point of concern. Is there any piece of legislation out there that guides applications that are close to such hazardous curves?
Not Not that I'm aware of. It's an existing township road, so it would have been designed appropriately. So while it may be a bit of a challenging turn, I'm quite confident it was constructed within any requirements when road construction takes place.
And in theory, with 2 courts, even if people played 2-on-2, they're unlikely to come in 8 separate cars. So it's not a huge increase. It is already a commercial property. I was on council when the application was made to put these the storage facility up, and it at the same time it was far more contentious than I mean, I wouldn't consider this contentious, and the same questions arose, and in that time, I wouldn't be fully aware, but I'm not aware of increased challenges or any accidents or life safety issues around that road. But I do know that at the time, the same questions were raised, and that's 12 years ago, because that's before either Lisa or Liz's time. And in that time, there's been no concerns. So if it was a 12-court prospect, it was going to increase traffic tremendously, I would have concerns. I think the space is small enough. We've heard the commitments from the manager, the property manager. The parking lot is there. I think we might, there's been a concern mentioned as a bit of a sidebar about some boats there that are a bit unsightly, but that's a bylaw issue. So looking for thoughts from council on what you'd like to do around this application. Yes, ma'am.
While I appreciate the concerns that have been raised and understand them, I think that they've also been addressed. Based on what's been applied for and the hours of operation, the information that we've received on the lights, I think we can move forward.
Mm-hmm. Are we able to, I guess zoning doesn't include, or can it include the hours? Can part of the language include the hours? My concern is, as we call it in planning, deck creep. I certainly hear loud and clear that Alicia doesn't want to pay folks to stick around in case somebody wants to play pickleball, but if it turns out to be really popular, you maybe don't want it late at night. So are there any concerns about that? And Sean, is it possible to include a limit of the hours? And if they wanted to increase the hours, they would have to seek permission from the municipality. Is that possible?
Unfortunately, no, we could not control hours of operation through a zoning bylaw.
That's worth asking. Okay, anybody else? Anybody else? Sounds like we're ready to go. Councillor Dayu.
Yeah, I am in support. I suppose my final niggle in my mind has to do with the sound and how sound carries, and pickleball can be fairly loud. And I just wonder, is there anything that can be said about that and how the grunts might carry over the water, or is that maybe Councillor Shortreed would know, being more familiar with the
With
property.
that area. I mean, it's up on a hill, like it's up above.
Yeah.
So I don't know that it would carry down, but I don't know. Anyway, I mean, there's existing noise anyways. There's tow motors and there's tractors and it's a commercial environment and there's boats going back and forth and whatnot. So, Councillor Shortreed.
So I've been there. It is heated boat storage, so it will be insulated. All right. And just for reference, it is a really bad corner, but the entrance to that building is way after that corner. It's not right on the corner. It's way after. So anybody going down that road, you have to drive slow because it is really, really sharp. So it doesn't matter who's driving on it. You have no choice.
But to go slow.
Oh, you have to.
Yeah.
You can't see. Yeah. But it is insulated, so I don't think there'll be any noise coming out of the building.
That's a good point about it being insulated because it's heated. Yeah.
Yeah.
Good point. Councillor Barry.
I appreciate the discussion and all of the concerns. And I think that I was comforted to hear about the operating hours that were stated. And given that that is summer use, hopefully the daylight won't even be an issue other than, if a deer comes by and turns on the light at night, but really the light shouldn't be caused by the use that's being proposed. And it is in a commercial zone with an existing use. So I support the application.
Yeah, and certainly if the lights are currently under the site plan control motion, if a deer is going through, I mean, it happens at my house, the deer goes through and the lights come on. So that would be happening now if it does happen. So, okay, so go ahead then.
Moved by Counselor Barry, second by Deputy Mayor Danielson, be it resolved, council adjourns its public meeting at 10:34 a.m. and the regular meeting resumed.
All in favor? It's carried.
Moved by Deputy Mayor Danielson, second by Counselor Barry, be it resolved, council acknowledge receipt of planning report PL 5522 prepared by Sean O'Callahan and dated April 21st, 2022 regarding proposed zoning bylaw update. And that council directs staff to bring back a report to the May 19th, 2022 council meeting addressing the public's comments, and further council directs staff to proceed with amendments if required and bring back the final draft, the comprehensive zoning bylaw to the May 19th, 2022 council meeting for further consideration.
All in favor? That's carried.
Moved by Counselor Shortreed, second by Counselor Barry. Be it resolved that council receive report PL 5622 regarding the rezoning of lands located at part of lot 15, concession 12, geographic township of Sherburne, submitted by Sean O'Callahan and dated April 21st, 2022. And the council directs a bylaw be tabled for consideration during its regular meeting.
All in favor? That's carried. You have nothing else for us at the moment, do you? Yeah, that's that for
That's
those. So looking with an eye to the time, I think we'll take a break for 15 minutes. And we'll see you back here then. Good morning, Greg.
Good morning, Mayor and Council.
Just one item up for you is monthly activities. Things are ramping up, I would assume.
They are indeed. We are on track to be the same as last year's totals. Another good month last month, about 30,000 in fees with 4.3 million in construction value. This month is tracking along the same. Beyond the normal activities of the month, I just wanted to mention also that later on in your agenda today, that there's going to be a bylaw to appoint Kristen Boylan, a municipal enforcement officer. So I just wanted to make sure that that was mentioned.
Yeah, we certainly welcome her to the team and look forward to her catching up on lots of things we'd like her to catch up on. So that's good news there. Does anybody have any questions of Greg? My Civic web screen has gone blank, so I'm on paper. If you look at the reports, Councillor Barry.
Yeah, just wanted clarification. At one time we were seeing them and I just don't see them this time. Just in regards to building permits, the 30 building permits, can you give a bit of an idea? Are those new builds or mainly additions? Just, I always like to know how much is being built here.
Greg, what do you say about that?
Yes, so I can certainly, I'm just trying to get that up here. It looks like last month we had 10 new dwellings. We had 6 commercial. We had 11 additions, rentals, and 29, or sorry, that's the totals. 17 accessory, 5 new dwellings, 3 commercial. So yeah, I could certainly break that down in the future if council wishes on the report.
Yeah, I think we had asked for that before, just so we can keep tabs on what's happening in the community. So we're on growth because we are, we know from the census we're 10% up. So were you going to say something?
Okay.
I was just going to say, I think David may have started doing that
Mhm.
just right at the end there, so.
Yeah, it rings a bell.
Mhm.
Okay, no more questions of Greg, then may we have the resolution, please?
Moved by Counselor Shortreed, second by Deputy Mayor Jansen. Be it resolved that council receives report BLDG 422 submitted by Greg Moore and dated April 21st, 2022 regarding March activities for information.
All in favor? That's carried. Thank you. Thank you, Greg.
Thank you.
There's no Parks, Rec and Trails business. Public Works business is next. So we'll bring in Mr. Thorne. Does everyone else have Civic Web up? Do your agendas up on your screen? Yeah. I'm loving the 100 up and down. Good morning, Adam.
Good morning, everyone.
A couple of things for you, 3 in fact. Monthly activities, things are heating up in Public Works, I would assume. Again,
Yes.
I don't have a report in front of me, so I can't tell you.
Yeah, nothing really to report other than, just with the weather getting warmer, we're cleaned out our ditch lines and cleaning out culverts to ensure water is running proficiently. And no floods this year, which was great, not having to deal with that and having to go through that process. But everything's moving along very well.
Great, thank you for that. Does anybody have any questions for Adam on the activities? What's going on in the department? Seeing none, we'll have a resolution, please.
Moved by Councillor Barry, second by Councillor Shortreed. Be it resolved, the council receives report PW 1522 regarding March monthly activities submitted by Angie Bird dated April 21st, 2022 for information.
All in favor? It's carried, thank you. Next up for you is truck purchase challenges.
Yes. Again, this year, the Township of Algonquin Highlands went with the County of Halliburton for a joint tender on pickup truck purchases. Unfortunately, we did only receive one bid. As the report shows, it was considerably over budget. So as the new world order has come about here, we're seeing these challenges across the board with almost every purchase. Every time we come to council, it's always something new with a purchase. So unfortunately, this is just one more thing. As the report shows, that we no longer are receiving some of the benefits we received in early years regarding municipal discounts, fleet discounts, things of that nature. So we're kind of bound to purchasing vehicles at retail price. And as such, I did reach out to a couple dealerships just to check on pricing and see where we stand. And I think it's reasonable that if we went out to a request for quotation, we would be able to get a pickup truck a little bit less than what came in at the tender.
My apologies, that's me. I've had to restart my computer. So, yeah, that is unfortunate. And the concern, certainly something I'd mentioned to the CAO yesterday is, we are seeing, we talked about this at budget, but we are seeing, projects coming in higher than even we anticipated with higher projections. So we'll need to keep an eye on that through the year because it's definitely of concern. But thoughts for how to go about getting this vehicle? Deputy Mayor Danielson.
I definitely agree with the recommendation that we're receiving from staff. I'm just wondering, Adam, if you heard from any of the dealers that there would be issues with respect to delivery and delivery times?
Through you, Mayor, yes, that was one of the questions I had as well, was delivery. Again, unfortunately, I'm being told between the dealerships I did speak to that it could be anywhere from 6 to 8 months for delivery. So, I mean, that puts us towards the end of the year, which would be okay. If I can get out to these dealerships this week and get it closed and something back to the next council meeting, which would be in May for approval, I would be thinking that we should see something by the end of the year, before the end of the year.
And is that okay for the condition of the vehicle in question?
Again, through you, Mayor, yes. No, right now we should be okay to get through the year with what we have currently. I know that this is a joint tender between Trails and myself, or Trails and Public Works. So I know their one truck that they did have that was being replaced is not usable currently. So I would like to work with the Trails manager on sharing some equipment to ensure that they have a truck for this season. And then we would definitely look at options as well, that if a truck does come in, I'm sure you might all be aware or have seen the 6-month turnaround that some of these people are doing online. And if a truck does come in and the person does not take it, it may be eligible for us to take something like that as long as it met our requirements. So I was going to have that in the quotation as well, that if something lands on their property sooner than the delivery date, that potentially we may be able to pick something like that up. I mean, that's a pretty big stretch in today's market, but that is going to be an option. So to answer your question, yes, we should be okay to get through to the end of the year utilizing equipment that we currently have and sharing.
Great, thank you for that, Deputy Mayor Danielson.
Just on the delivery time, I'm assuming that we would have price protection even though it might be towards the end of the year before the truck's actually delivered?
I'm sorry, could you repeat that question?
Would there be price protection on the vehicle, even though it might be towards the end of the year before it's delivered?
That is something that I would definitely confirm in the quotation, but typically, yes. I have in the past have seen where, a vehicle does take that long to get to us. Actually, our last purchase of a pickup truck that was closed in the fall last year, we still have not received. And to my understanding, it's the price that was set when the tender closed is the price that we will receive.
Yeah, that's good to know. That's a good question because things are shifting rapidly. Any further questions about the acquisition of vehicle? Okay, can we have a resolution, please?
Moved by Councillor Shortreed, second by Councillor Barry. Be it resolved that Council receives report PW 1622 regarding the pickup truck purchases submitted by Adam Thorne dated April 21st, 2022. And Council hereby concurs with the recommendations made in the said report to provide a request for quotation with the vehicle specifications from the original tender to the 3 area dealerships. And further, the Council directs that a report be brought forward at a future meeting outlining the estimates received and recommendations for the purchase of the 2 pickup trucks.
All in favor? It's carried. Thank you. And lastly is the Product Care Association amending agreement. I don't think there's much discussion there. It's just the agreement. I'm not on.
Yes,
am I? Yeah, I am. Yeah, so there's nothing to discuss there. Any questions? Oh, go ahead, please.
Moved by Councillor Barry, second by Councillor Shortreed. Be it resolved that Council receives the Product Care Association amending agreement and directs a bylaw be brought forward to approve the execution of the agreement.
All in favor? It's carried. Thank you. Thank you, Mr. Thorne.
Thank you, everyone.
Fire service business is next, so we'll bring in the fire chief. Good morning, Chief.
Morning, Mayor and Council.
We have your report in front of us, your activity report. It's everything's there. Is there anything you'd like to highlight for us?
Yes, definitely. In the correspondence, there was a letter from Emergency Management Ontario, and what it was for is in regards of compliance. And the Township of Algonquin Highlands is compliant with the Emergency Management and Civil Protection Act again in 2021, and I think that just reflects back to how much council and the EOC work together to ensure the health and safety of our employees during the COVID and that. And we have met all requirements. And I think, again, it's the cooperative effort through council and the EOC to achieve that. So I think it's a real accomplishment for that time period.
Yeah, there was difficult times, and I know there was a lot of confusion around the annual emergency exercises and a bit of a change of heart at the upper levels. So I'm glad that it was all sorted out and that we have received that. So good news. Any questions from council for the fire chief on his report? We may have the resolution, please.
Moved by Councillor Shortreed, second by Deputy Mayor Danielson. Be it resolved, Council receives Fire Services Report FD 1022 regarding monthly activities submitted by Michael French dated April 21st, 2022.
All in favor? That's carried. Thank you. Thank you, Chief.
Thank you. Have a good day, everybody.
Yeah, you too. Thanks. Next up is finance business. It's the account summary. We're not bringing the treasurer in for this, are we? Anybody need to talk to the treasurer about that? The account listings are there. Does anybody have any questions that would require the treasurer? Nope. Then we have a resolution.
Moved by Councillor Dayu, second by Councillor Barry. Be it resolved, Council has reviewed the expenditures incurred as set out in the account summary report TT 1422 in the total amount of $2,631,401.03 and hereby approves payment of same.
All in favor? It's carried. Thank you. Next, we're just blistering pace now. Administration business, we have report on lame duck, which to me read like 2 trains left the station.
My apologies.
So my head just exploded and I just went into a panic mode.
Thank you, Mayor and Council. So before council is a report, which highlights the 2 timeframes during the election year where council may become lame duck. And it also highlights during the lame duck provisions 4 restricted acts, and they're identified in the report. So what staff is requesting is that council provide direction if they wish to see those 4 acts. And it's common practice that council does delegate those to the CAO during the lame duck provision should they prevail, and they're only in effect if there's a lame duck provision and then expire after that. So if council's in agreement, the bylaw would come back at the next regular council meeting for approval.
Yeah, I mean, it's something that gets done every 4 years in preparation for the election. Any questions, comments, concerns? Nope. So we'll see that we'll see that bylaw come back. So go ahead.
Moved by Deputy Mayor Dennison, second by Councillor Dayou. Be it resolved that council acknowledge receipt of report CO 1222 regarding restricted acts after nomination day submitted by Don Newhook dated April 21st, 2022, and that council hereby concurs with the recommendation to delegate its powers under section 2753 of the Municipal Act to the Chief Administrative Officer and directs that a bylaw be brought forward at a future meeting of council for consideration.
All in favor? It's carried. Thank you. And thank you for that report. I'm better now. Planning business is next, so we'll bring Mr. O'Callaghan back in. Welcome back, Sean.
Thank you.
First up for you is the report on the consolidated planning fees. And this is coming out of the service delivery review work that's been done. And just would like to thank you for your part in what clearly has been a tremendous amount of work on this. So thank you for your efforts there, and take it away.
Yeah, thank you. It's been an excellent group project that the planners and CAOs have been working on. And this is the result we have proposed here today to consolidate all of our fees so they would be the same across Haliburton County, with the hopes of that being a little easier for people to anticipate any potential costs when they are applying for any of these planning applications. No matter which township they're applying for them in. So I won't go through the table, but if there are any questions, I'm certainly happy to address them. I guess one thing to note would be we did take the higher of the fees when looking at all the other townships, but for Algonquin, Highlands, and the most applications we generally receive would be minor variances and short road closures. Those fees have not changed. They have not increased. So they remain the same as what they are currently.
Great, thank you. And that's one of the things in whether it's, looking at consolidation of processes and fees through the service delivery review, or whether it's a full-on, amalgamation discussion that is often happening in the public these days is we've always said things aggregate up. So there won't be less money or less people to do any work that, even if it's just a consolidation, you aggregate up. So that's what happens. Questions from council on Sean's report and this process? Deputy Mayor Danielson.
Not a question, just a couple of comments. While I was a bit surprised to see the increase in some of the fees, that was sort of ameliorated by the fact that our applications are mostly, of a lesser nature, so that our fees, in fact, won't increase. I'm just really pleased to see the work that's gone into that. As you said, this has been an interesting part of the service delivery review, and I know that it's going to make things easier for people across the county. So it's a good piece of work.
Yeah, it is definitely. Councillor Dayou.
Thanks. Knowing full well that I'm about to replicate what Deputy Mayor Danielson just said, I do want to stress that I had a great conversation with Sean about this yesterday, because when I opened up the report, my first thought was, yowza, some of those fee increases are really, really big. And Sean very graciously went through each table with me and was able to confirm beyond shadow of a doubt that, you know, Joe and Molly down the street with their very standard cottage or residence will simply not feel these changes at all. These are really about significant changes, which are incredibly rare in our township. And the applicants who would be applying for some of these changes would probably experience these fee increases to be a drop in the bucket of the overall project cost of the initiative that they're proposing. So I felt really confident after speaking to Sean that these were going to be fine for the average Ontario Highlands resident.
Mhm. Yeah, it's good work. Any other questions for Sean on this report? Resolution, please.
Moved by Councillor Short Reed, seconded by Councillor Berry. Be it resolved that council receives report PL 5722 regarding the service delivery review consolidated planning fees submitted by Sean O'Callaghan and dated April 21st, 2022. And that council directs a bylaw be tabled for consideration during a future meeting of council.
All in favor? It's carried. Thank you. And secondly, for you is a bylaw for a shore road closing.
Yes, this is a bylaw to close the shore road allowance in front of this property on Couchog Lake. It was circulated for comment to the neighboring property owners and to the required agencies. No comments or objection, and staff would recommend approval of the bylaw as presented.
Thank you. Any questions, comments from council? Go ahead.
Moved by Councillor Berry, seconded by Deputy Mayor Danielson. Be it resolved the council receives report PL 5822 regarding proposed shore road allowance closing fronting property located at part of Lot 2, Concession 5, Geographic Township of Stanhope, Couchog Lake, submitted by Sean O'Callaghan, dated April 21st, 2022, and that council deems the said shore road allowance to be surplus and directs a bylaw to stop up closing of the said shore road allowance be tabled for further consideration.
All in favor? It's carried. Thank you. Thank you, Sean.
Thank you.
External boards, I ask the same question every time. I don't think anybody's meeting just yet. There are plans to meet, but no one has yet met. I'm just sort of scanning the room, looking for thoughts. Madam Warden, anything from Eorn?
Sorry, no updates to provide at this time.
And I missed, so in terms of the safety and well-being plan, the county has put the job out to market for that. I call it a navigator, but that's a coordinator for that process. So we'll look forward to those meetings resuming, hopefully when somebody gets that job. The Muskoka Watershed Communications Committee, I did miss the last meeting. I had a conflict, but certainly with the mild spring we've had, rushing water has not been a problem this year. So things are all status quo there. Library, anything for library that you want to say? Hasn't met. Oh, maybe it met last week. I was away. Okay, that being that, general business, we have the final draft, the climate action plan from submitted by Corey McKay. Council did see it at the last meeting. It's now done the rounds and it's just back for final ratification. Does anybody have any thoughts on it? Go ahead, please.
Moved by Deputy Mayor Danielson, second by Councillor Berry. Be it resolved the council receives report from Corey McKay, Climate Change Coordinator, dated April 21st, 2022, regarding the corporate climate change and adaptation plan, and the council approves the corporate change adaptation plan as presented.
All in favor? That's carried. Thank you. Any notice of motion? Correspondence, I believe something was moved and seconded. Sorry, I'd like to ask the mover to speak to what they'd like moved. Okay, do you guys want to, either one of you want to speak to what you moved and why? Why you'd like our support on it? Yes, ma'am.
I'm really concerned about this act overall and the province appearing to take control away from the municipalities. I truly believe that municipalities know better what's suited for our individual areas. And, when I hear things like developments taking place in protected areas and wetlands, I believe that control should remain within the municipalities. And I don't know for sure whether I agree with every point that Momar has made, But I do believe that we should make a statement suggesting that we're concerned about control being taken away from local municipalities.
Yeah, I agree. And I think that, we saw evidence of a bit of an upending of the process when there was the webinar a couple of weeks ago, 3 weeks ago. And then certainly the minister spoke and seemed to rake municipalities across the province over the coals about these, these inadequacies. And I remember watching what he was saying and thinking, well, we don't do that. And yet every municipality is being blamed for, as has been mentioned, inappropriate building or, wetland use and whatnot. And do I disagree that that happens? No, I don't, but it doesn't happen here. So what they should do is put the hammer down on those who are on the transgressors. They should put the hammer down on the transgressors and not paint all with a brush. So it's good that this has been brought forward. Do you have something else you want to add to that?
Well, just that in some cases, it's been the province that's promoted development in those areas.
Oh, by reducing all that red tape. Yes. We could have an entire meeting on that. Okay, so we have a mover and a seconder for that, and Madam CAO.
I know that the planner is going to bring a report to council on this bill at the next meeting. So I didn't know if council wanted to wait or if this is okay to go ahead and he still bring the report.
If there's some things in it from the Mulmer that you're not, the couple of points that you're not convinced about, and there is something coming forward, we can not do this and then make sure that our response is crafted specifically based on our planning report.
I would welcome that.
Yeah, some nodding heads there. Okay, so we can just fold that piece of paper in half. So great, that's good. That's good to know. And then we have a resolution for the correspondence listing. Yes.
Moved by Councillor Dayu, second by Councillor Barry. Be it resolved that council receives the April 21st, 22 correspondence listing for information.
All in favor? It's carried. Thank you. And we will be moving into closed session. So go ahead.
Moved by Councillor Barry, second by Councillor Dayu. Be it resolved that council adjourns its open session at 11:22 a.m. in order to proceed into closed session for the purpose of discussing personnel matters about identifiable individual, including municipal or local board employees, litigation or potential litigation, including matters before administrative tribunals, and advice subject to solicitor-client privilege in accordance with section 2392B, E, and F of the Municipal Act 2001 SO 2001 as amended, zoning compliance matter.
All in favor? It's carried. Thank you. Thank you. We're back live. May we have the resolution to resume the open session?
Moved by Deputy Mayor Dennison, seconded by Councillor Short-Reed. Be it resolved that council adjourns its closed session at 12:23 p.m. and open session resumed.
All in favor? That's carried. Bylaws.
Moved by Councillor Barry, second by Councillor Dayu. Be it resolved the following bylaws be received and read a first time, considered read a second and third time, and finally passed with a corporate seal affixed. 2022-44 being a bylaw to amend the comprehensive zoning bylaw of the Township of Algonquin Highlands, application A, said BA 222, part of lot 15, concession 12, geographic Township of Sherburne. 2022-45 being a bylaw to stop up closing of a part of the original Shore Road allowance in front of lot 2, concession 5, geographic Township of Stanhope, Cushog Lake, Chalmers. 2022-46 being a bylaw to authorize the mayor and clerk to execute an agreement with Product Care Association of Canada. 2022-47 being a bylaw to appoint a municipal law enforcement officer, Kristen Boylan.
All in favor? Carried. Thank you. Confirmatory bylaw.
Moved by Councillor Barry, second by Deputy Mayor Dennison. Be it resolved that bylaw 2022-48 being a bylaw to confirm the proceedings of council held during its April 21st, 2022 regular meeting be received and read a first time, considered read a second and third time, and finally passed with the corporate seal affixed.
All in favor? It's carried. And adjournment.
Moved by Deputy Mayor Dennison, second by Councillor Barry. Be it resolved that the April 21st, 2022 regular council meeting is hereby adjourned at 12:24 p.m.
All in favor?